Good afternoon, everyone, and welcome to the last in our series of oil and gas webinars. This one will focus on the new regulatory regime that was put in place in October this year for offshore UKCS. My name is Tom Swan. I'm an associate in the corporate team, and I'm with Gordon Downie here, who is a partner in our regulation and market team. Just a little bit of housekeeping before we get on to the presentation proper. If any of you have any questions at any point, then please just use the chat box, and we'll maybe deal with questions at the end. So what are we going to cover today? I think we're going to have a quick brief look at the new regulatory framework that is in place at a high level, and talk in particular about the MER UK, Maximising Economic Recovery UK strategy that the OGA has now published, and which is really a key document in the regulatory framework. We'll then have a brief look at the regulatory powers that are available to the OGA, and in particular the new regulatory powers relating to meetings and the new dispute resolution procedure, and the sanctions that are available to the OGA if people fail to comply with their obligations. And finally, we'll discuss the kind of just more general regulatory approach that the OGA are going to take. I should say at the outset that the regulatory regime we're in, to some extent, uncharted waters here. The OGA is really a proper economic regulator now, with a mandate to, and I think resources to take a more active role in the UKCS than DEC had previously taken. But the regime that it's operating under, and in particular the MER UK strategy and the way that fits within this framework, is really very different from any other regulatory regime, really, I think, in around the world.
Okay, thanks, Tom. So what I want to do in this section is to talk a little bit about the regulatory framework under which the OGA is operating. This slide is very useful and was prepared and given by Simon Toole, who's the OGA Director of Regulation at the MER UK in Practice event held in Aberdeen at the end of October, which some of you may have attended. And it's a good overview really of our topic today, in terms of outlining, first of all, the statutory role of and the underpinning for the OGA, and that's of course partly about transferring existing functions of the Secretary of State to the OGA, notably in relation to the licensing regime, and partly about conferring brand new functions on the OGA in relation to obviously the MER UK strategy. It also usefully highlights the central role that's played in the framework by the MER UK strategy itself as the foundation for regulatory activity. And of course it also shows helpfully the powers that are available to the OGA, and Tom's mentioned sanctions, for example, already, to execute, as the slide puts it, the OGA strategy, and also to enforce compliance with the strategy. Next slide touches on the question of statutory duties. So it's important to recall that the OGA is a creature of statute. And so as a general proposition, it can only do those things that it's empowered to do by statute, and in doing so it has to operate within the constraints which statute imposes. There's a central role there in the purple segment of the OGA statutory duty under Section 9B of the Petroleum Act, that it must operate, or must act, sorry, in accordance with the MER UK strategy. And that's important both as a driver for OGA action, and also as a constraint on OGA action, and we'll come back to talk about that shortly. Interestingly, Section 9E of the Petroleum Act says that there's an exception to that duty, where, in the context of the OGA exercising its security and resilience functions. Those functions aren't defined in or prescriptively defined in the Act. Simply relates to any function which concerns the security of petroleum supplies or the resilience of the petroleum industry. So it is unclear, I think, quite what those functions are, and if the test in 9E is triggered, what the framework for action would be. But leaving that to one side, there are a set of other factors in addition to the MER UK strategy which the OGA has to take into account when performing its statutory duties. Perhaps the most important ones to draw out in this presentation are, firstly, collaboration, the need, in other words, for the OGA to work collaboratively with those in the sector. Secondly, innovation, the need for the OGA in its activities to encourage innovation, both in relation to technology and also working practices. And thirdly, system of regulation, in other words, for the OGA to recognise the need to maintain a stable and predictable system of regulation which encourages investment. Should also note, before we move on, the power of the Secretary of State to give guidance to the OGA in the conduct of its functions, and also for it to receive directions from the Secretary of State. Not provisions that you would expect where there was a large degree of independence, but I guess operationally speaking, that's the intention, is that the OGA will operate independently of the Secretary of State. So turning to the MER UK strategy itself, a few words in relation to the structure of the strategy. It's important to distinguish it, first of all, from, in terms of legal effect, from the other strategies that are being developed by the OGA within industry. This is the strategy that has statutory effect. It binds the OGA and also participants in the sector. It's structured with an introductory section which explains how the strategy has been formulated. Those are the high-level principles, and those are likely to be relevant when it comes to interpreting the strategy. We then have a central obligation which is expressed at the highest level of generality. It's the general obligation to take all necessary steps. And then there are a series of more detailed supporting obligations as regards particular steps to be taken in particular contexts. So, for example, in relation to exploration, development, technology, decommissioning, and so forth. It's not yet clear, given how early in the process we are of the OGA regime, to what extent, if any, these supporting obligations trump, in any sense, or supplant the central obligation in a particular context. And then we have a set of required actions and behaviours addressing the manner in which that people should go about implementing the central supporting obligations in particular contexts. And then there are a series of safeguards provided for, and we'll come on to talk about those now. So those fall into broadly three categories. Before we talk about them, it is important to bear in mind that in a sense, the key strategy, the key safeguard for participants in the sector is, of course, the strategy itself, which acts as a constraint on the OGA's freedom of manoeuvre, and so therefore where regulatory action it takes is not, quotes, in accordance with the strategy, then it is limited in what it can do. But looking at the express safeguards that are set down in the strategy, firstly we've got legality, which is a requirement that nothing in the strategy requires conduct which would otherwise be prohibited by law, and we've talked recently, in fact, about competition law as an example of that, the way in which that safeguard operates. There are also references in that context to the common law duties of the OGA to act reasonably. In terms of substantive constraints, that's in many ways the most important part of the safeguards section. That's the section which requires that there be a satisfactory expected commercial return on investment or funding of activity which is required under the strategy, fair and reasonable contribution towards cost by those benefiting from activity, and the requirement that the cost-benefit rationale be made out for activity, setting aside the costs, setting the costs of activity or funding against investor confidence in the sector. And then, as regards enforcement, there is a requirement, reasonably dilute, in relation to the OGA discussing enforcement action before it is taken, where there has been delay or a failure to undertake investment or to fund activity. As I've said, the substantive constraints are probably the most interesting aspect of the safeguards, and they raise an important set of important questions on how the OGA will be constrained, which will no doubt be decided in future cases. But just to give one example, when one looks at the safeguard concerning fair and reasonable contribution, a question arises, for instance, as to how that safeguard will work in a context where an undertaking to make such a contribution isn't actually forthcoming on the part of a market participant, or, for example, if the undertaking to contribute is made and is then not actually delivered. So those are questions which will have to be addressed in due course. Just touching on the required actions and behaviours segment of the strategy, those cut across both the central and the supporting obligations, and in imposing obligations, for example, in relation to the timing dimension of complying with the strategy, the need for collaboration, although it's important to note that the collaboration requirement is reasonably qualified, and that all that's required under that RAB is that the possibility of collaboration is identified, and due consideration is given to the possibility of being pursued. There's also an obligation to cooperate with the OGA. Contrast that with the cost reduction RAB, which is an extensive one, which imposes a general and, on the face of it, a self-standing obligation to reduce full life cycle costs of various activities as far as possible. Finally, in relation to the RABs, the very important requirement that in circumstances where a participant is either not able to pursue their MER obligation, or they decide not to do so, to allow others to exploit their licences and infrastructure, subject to, of course, the proviso relating to fair market value compensation or reasonable terms and conditions. The final part, I think, in this section before I hand back to Tom, is just in relation to stewardship expectations, which, as I said earlier, form part of the OGA's wider strategy and not the legally enforceable MER UK strategy. They've been developed by the OGA along with industry, and cover a whole range of topics which are shown on the slide, and are intended to set what are described as good practice expectations, which are aligned with the supporting obligations in the strategy, and are designed to help achieve consistent stewardship performance. And they're accompanied by, or will be, an implementation guide to support what is actually required under each expectation. Now, important statement which I wanted to highlight is in the box on the slide from the OGA, which makes clear that where an expectation has not been achieved following discussions with the licensee, the OGA may consider whether or not the licensee is complying with their obligations under the MER UK strategy itself. So the proposition appears to be that non-compliance with the stewardship expectations may amount to non-compliance with the strategy, and that raises two important questions, which I'll leave you with. Firstly, to what extent is the OGA going to use the expectations to provide an evidential standard against which to assess compliance with the strategy, rather than relying on the strategy itself? And secondly, to what extent is performance against those expectations to be the focus of the OGA's enforcement activity? So with that, I'll hand back to Tom.
Thanks, Gordon. So we're into the sort of second section of the presentation this afternoon, which is on the regulatory powers of the OGA there. And helpfully this slide, again, which came from the OGA, sets out, I guess at a high level, the various regulatory powers that the OGA has. The two boxes in green at the top there are really existing powers that DEC had, and that have been transferred to the OGA as a result of the implementation of the Energy Act 2016. So the first one there is enforcement of the model clause terms in licences. Those terms, largely everyone will be familiar with them, tend to be negative rights, generally prevent activity if they're exercised. So work programs are in those in licences. A range of consents that are required, so wells and field development plans in particular, cessation of production consents at the end of a field's life, and the various controls on licence assignments and change of controls. The other box there on the right-hand side, third-party access, that refers to the third-party access regime under the Energy Act 2011 and Gas Act 1995, which is complemented by the Oil and Gas UK Infrastructure Code of Practice, which is, as everyone will be aware, a non-binding code of practice on upstream infrastructure access. So the OGA has a role to play and has taken over DEC's role in that third-party access arrangement. Possibly the most relevant and most important regulatory power that the OGA has been given as a result of the Energy Act 2016 is really the general power to enforce compliance with the MER UK strategy, and that's probably the area where there is most scope for regulatory disputes. It's going to directly affect upstream participants' decision making, and the OGA are going to be interested in making sure that that strategy is complied with. The other three powers in the middle line there in blue are really ancillary to that. First one is obligation to, or rights to attend external meetings, which we'll come on to. Second one there is powers in relation to information and samples, which supplements the already fairly broad powers in the model clauses as applied by DEC under Petroleum Operation Notice number 9, which describes what those requirements are. And the Energy Act gives very broad powers on the Secretary of State to make regulations regarding the provision of information and samples. Those regulations haven't yet been made, but the OGA is talking about consulting on recommendations to BES on what these regulations should say. And importantly, the other aspect of the information and samples regime is the requirement to produce information and samples plans in relation to what happens to information and samples after the licence terminates or on a transfer of the licence. And the reason for that is that it was thought that a lot of information and samples were going to be lost as a result of licence transfers or licence relinquishments, and that is in place to ensure someone gets that information and that there's a sensible and organised plan in place as to how that's going to happen. So we move on to the next slide. So this is these are probably the two most contentious powers that the OGA have been given in terms of the things that have caused the most concern in industry. Meetings is a particularly contentious area, or caused most concern, I think, out of all of this, really because of the very general right of the OGA to attend and have summaries of discussions at any meetings between two or more relevant persons to discuss, which are basically operators, license holders or owners of infrastructure, to discuss relevant issues, which are basically issues relevant to MER UK or any activities under an offshore license, which is obviously hugely wide. So that caused a lot of concern in industry, really, because that arguably covered thousands and thousands of meetings every year. As a result of that concern, the OGA issued a statutory notice which narrowed the scope of the meetings that the OGA want to receive notice of and summaries of. And effectively, there's four legs. There's operating committee meetings, or OCMs, in respect of particular fields where there's ongoing development, where there's significant production, and or where there's significant decommissioning likely to happen, or is already happening, and then particular pieces of important infrastructure, so Forties, pipeline, Sullom terminal, Shetland gas plant, as well. So these fields and these bits of infrastructure are specifically called out and named in the notice. And equally, the OGA want to have notice of and receive records of TCM meetings in connection with these fields and these pieces of infrastructure. So if you're not involved in any of these fields or infrastructure, then the only meetings that you need to give notice of or provide summaries to the OGA of discussions at are pre-investment meetings in relation to exploration and appraisal wells, where there is a technical peer review on prospects for a discovery or an undeveloped field, with the intent that that might lead to an investment decision in relation to drilling a well. And also, separately from that, major project review meetings, so decision gate meetings between JV participants for major investment projects of 300 million or more for greenfield, brownfield or decommissioning projects. So that notice has really narrowed down the scope of what the OGA wants to, is interested in quite significantly. Moving on to dispute resolution, this was a new procedure that was introduced in the Energy Act 2016, really as a way of giving partners and participants in the industry an ability to go off and try and resolve their disputes in a forum which isn't a court. It's not really intended to deal with legal or contractual disputes. I think it's more likely to be dealt with where there is some sort of commercial dispute about the way that a development should or a project should be run, or whether an investment should be made. It won't be used, the OGA have said, in relation to any access to infrastructure negotiations that are already covered by the procedure in the Energy Act 2011. Importantly, the OGA can act on its own initiative to start the dispute resolution procedure, or a dispute can be referred to it by a party to the negotiations. And at the end of the process, the OGA will publish a final recommendation. That recommendation is non-binding, but but the OGA have said that effectively where the subject matter of the dispute relates to how the principal objective is to be met, which is likely to be most of the disputes, it's likely that the OGA will expect it to be followed. And again, this comes back to Gordon's point on the asset stewardship expectations, is that whenever the OGA are making a decision on how the principal objective is to be met, it's likely that the OGA are going to consider that that is a requirement, a regulatory requirement, given the requirement on all industry participants to comply with the MER UK strategy. So the non-binding nature is perhaps a misnomer, and I suspect that that might result in people being a little bit more careful about what disputes they take into this procedure. So moving on to sanctions, there's a number of sanctions which the OGA have been given, a number of new sanctions. The existing sanctions which DEC had for failure to comply with licence clauses remain, so ultimately the ultimate sanction is taking a licence holder off the licence, or if they're an operator, removing their consent to operate. Those sanctions remain. However, they're supplemented by a number of other sanctions, including financial penalties, really because it was thought that that nuclear option of taking licences away or removing operator consent meant that there was really no teeth for breaches of licence terms. In terms of what can be sanctioned, it's the Act provides that it's a failure to comply with a petroleum-related requirement. What is that? Well, it's the general duty to act in accordance with the MER UK strategy. It's a failure to comply with an offshore licence, and it's a failure to comply with various provisions of the Energy Act 2016, which are sanctionable in accordance with that Act. So failure to comply with information and samples provisions, for example, failure to comply with the meeting provisions is sanctionable. So there's a kind of gradient of notices that can be given. The first step will normally be an enforcement notice, which will require a licence holder or relevant person to comply with a relevant requirement, and give directions as to the measures that are being taken so that compliance can be achieved. Failure to comply with any of those directions is in itself sanctionable under the Energy Act. That can then lead to a financial penalty notice where the OGA can levy a fine of up to £1 million, or, as I said, a revocation notice for a licence or an operator removal notice. The OGA I think they've finished the consultation on financial penalty guidance that they have produced that ran in October, and there's a number of criteria that the OGA must take into account that are set out in that guidance when assessing the amount of financial penalty. So they look at, for example, financial gain that anyone has obtained as a result of the breach, or the relevant failure to comply, the severity of the breach, the harm caused. They'll also look at a number of mitigating factors, including the action that a participant has taken to address and the cooperation that they have undertaken with the OGA in connection with any investigations, and also any aggravating factors, and including whether the failure to comply has been persistent and there's been senior management involvement in it. There's the guidance itself is quite useful if you're faced with potential sanction. There's various stages to it, and a separation of the inquiry and investigation stage from the making of the enforcement decision. And at the moment, the enforcement decisions are going to be made by the OGA board as a whole, so at quite a high level within, or the highest level within the OGA. One thing that that will be is important to understand if you're faced with a sanction procedure is what the effect of a sanctions warning notice is. Now that's really a warning that a notice that's being issued after the initial decision to sanction has been made, so right at the end of the process. Now that allows participants to make representations on the penalty that has been is proposed, and the extent to which that penalty should be levelled at all. What it isn't is a last chance to comply, and it shouldn't be taken as such. So once you have received the sanctions warning notice, then the OGA are going to be fairly set on exercising an enforcement power, unless there's good reasons not to. But the OGA have really said that the sanctions should be rare because their activities their sort of facilitation activities earlier on in the process, their discussions, their involvement in discussions in relation to significant decisions should mean that that their views are clearly communicated to participants before there's ever a breach of a petroleum related requirement. But they've also said, on the other hand, that they won't wait to see, and they won't make enforcement an absolute last resort, and that they will proactively use sanctions where they think that there's been a significant failure to comply with the strategy. And there's various appeal or review powers. It's important to note that those appeals are probably going to be particularly limited because the scope to appeal to the first tier tribunal, which is the regulatory tribunal, is only ever going to be on grounds that the OGA have failed themselves to comply with the strategy, which, given the terms of the strategy, is going to be quite hard, or that their actions were in somehow not reasonable, which again is going to be a difficult test to meet. So the OGA really, as a combination of its regulatory position and the breadth of the strategy, has pretty significant powers here. And finally, just on penalties and sanctions, it's important to bear in mind that there's obviously the scope of getting the sanction, or having a sanction levied against you itself, which is consequential and can have a financial impact. But you need to be careful to bear in mind the kind of indirect impacts on contractual covenants. So, for example, borrowing covenants of there being sanctions and enforcement made against you, which, albeit that you don't lose the license, it might be a relatively low financial penalty, could give counterparties claims against relevant persons.
Thanks, Tom. Moving into the final section of our presentation, and again a slide which OGA itself has produced on its approach and the way in which the various avenues for regulatory action will be assessed by it. And I think the box at the top showing the two-way movement, I think, is intended to communicate a wish on the OGA's part, not necessarily to move in one direction down an enforcement route, for example, but rather to have these various strands available as part of its efforts to facilitate activity and delivery of the strategy, in particular in relation to the importance of or the ability to resort to enforcement action. There's a very strong statement, in fact, in the OGA's current corporate plan to the effect that the OGA will only deploy sanctions in circumstances where all other avenues have been attempted and the issues have not been resolved. And that's a reasonably unequivocal statement, which I would expect people to look to rely upon if the OGA are looking be a little trigger happy with their use of sanctions. Also worth bearing in mind in this slide, it's very difficult to make out on the screen, but in the context of evidence of failure to comply, the note that's given on that to that box under the sanctions stream states that evidence in support of failure to comply with the central obligation may include, depending on context, such things as the person's underperformance against the OGA's published stewardship expectations or an OGA plan. So that underpins what we've been saying, I think, earlier in the presentation about the importance of the stewardship expectations, in particular in the context of the willingness of the OGA to pursue enforcement action, the use of their enforcement powers. And in relation to that, I think what we've done on this slide, I think, is just to draw together the way in which the OGA see themselves as being able to take regulatory action, and the ways in which they can build a case for regulatory action, whether that's through, as it says there, the development of the MER UK strategy, or indeed articulating these stewardship expectations, through the gathering of intelligence and understanding, through participation in meetings which can then be used to inform regulatory action, and then obviously also the dispute resolution power, in particular the power, as Tom has said, to exercise on their own initiative intervention in disputes. And noting on the slide there, of course, that, as Tom has said, these are not disputes necessarily, or indeed mainly, concerned with legal matters. They are most likely disputes concerning the implementation of the MER UK strategy. And of course, that's an area that has, as Tom has said, generated a lot of anxiety. The call for evidence that was put out by DEC around the establishment of the OGA did note that concerns have been raised as to the interaction between the dispute resolution exercise or process and the sanctioning regime. And what it said is that whilst the, as DEC put it, the simple failure to comply with an opinion issued by OGA following the dispute resolution process would not result in sanctions being imposed, where a failure to comply with the OGA's opinion goes further and ultimately results in a breach of the strategy or, for example, licence conditions, then the OGA will have power to move to enforcement action and impose sanctions for that breach. And therefore, as DEC concluded, the outcomes of the dispute resolution process are intended to be a strong and effective contributor to the delivery of MER UK and inform the enforcement work of the OGA. So I think still grounds for concern about how these dispute resolution powers will inform decisions around notably sanctions. In this final slide, we've taken the opportunity just to perhaps bring to life a little bit the way in which the OGA might be expected to use its strategy development, possibly also dispute resolution powers in tandem to enforce the strategy against market participants. So, taking the example of supporting obligation paragraph 21 in the strategy, requiring regulated persons to decommission infrastructure in a cost-effective way. The way in which that supporting obligation might be elaborated might be through the assessment of compliance against that supporting obligation via the stewardship expectation on decommissioning, or indeed via an opinion which the OGA might issue in relation to a dispute on supporting that supporting obligation in a particular context. And what then might arise is a direction from the OGA under its direction-giving powers that in order to comply with the relevant supporting obligation, you being the relevant person, undertake decommissioning of asset X in the following manner. And it will be then that direction and the obligations contained in that direction which would then result or be enforceable by financial penalty, removal, operator removal, revocation, etc. So in that way we get from a very general level in the MER UK strategy to something very specific, which can then be the result of enforcement. So that is the final slide in that section, and there's now an opportunity for questions, and we've got one I can see in the chat box, which I think is probably directed at Tom. Question is, what is the legal significance of the OGA being established as a company, and how does that affect the way it operates as a regulator?
So I guess it's first thing to say there is that I suppose the OGA being a company is not unusual in regulatory frameworks. In the United Kingdom, the FSA was a wholly owned company owned by the Treasury, I think, and as is the FCA now. So that's fairly common. I think what it does do is put the arms regulator, and is intended to do, is put the arms regulator at arm's length from government, and try to ensure that regulatory decisions are not influenced by on a day-to-day basis by government. So from that point of view, it tries to separate out, I guess, the policy activity the government has in setting the general policy agenda and the general framework from actual operational regulatory decisions on a day-to-day basis.
Okay. I don't think we have any more questions at the moment. So I think at this point, Tom, we probably want to draw things to a close. Is there anything you want to say in closing?
No, I think if anyone has any questions for us, then by all means drop us an email, and we'll endeavour to answer those questions. I think we are living in a slightly changing world, and the OGA have been very good about engaging with industry, both in connection with their consulting on their guidance and on the strategy, and they seem to be taking a much more active approach and are much better resourced than the DEX teams were. So certainly the next 2 or 3 years will be interesting as they begin to find their feet, and as you start to get regulatory decisions in areas of contention, and where really that is affecting people's bottom line, and we'll then see just how the regime works in practice.
Okay, thanks everyone.
Thank you.
Goodbye.